Well, let's continue with the story then this evening. Former President Jacob Zuma has been ordered by the Apex Court to hand himself over to either the Nkandla or Johannesburg Central Police Station. If he fails to do so, it will be the job of the Police Minister, Bekele, and the National Commissioner of Police to arrange for his arrest. For more on this, we're joined by criminal justice analyst Kelly Phelps and Dan Mafora, who's a researcher at the Council for the Advancement of the South African Constitution. Just listening to what the spokesperson for former President Jacob Zuma, Mzwanele Manyi, was saying coming into this interview, that the minority judgment effectively is saying that the steps that are being taken in terms of the punishment here are unconstitutional. Do you think that the finding of the minority judgment dilutes what the majority have ultimately decided in this instance? Kelly, let me begin with you.
Well, I certainly think it's unfortunate that it wasn't a unanimous decision of the court, because, of course, that just leaves room open for future doubt and contestation. I don't agree that the differences between the majority and the minority judgment were based on political grounds, that they were political differences. My reading of the two judgments is that they squarely disagreed on interpretations of the law, which is their role as a court, is to interpret the law. Unfortunately, this case is treading on ground that hasn't been charted up till now. So it shouldn't be entirely surprising that different judicial officers have different interpretations of the correct way forward. That's how new terrain in law is forged, by judicial officers applying their minds and giving what they believe to be the correct interpretation of the law. In this instance, the majority of the court were of one view, and the minority, made up of two justices, had a different opinion on that. And unfortunately, it will, because this hasn't been encountered before, it will really be down to, lawyers and legal academics and future courts to eventually show us which of those interpretations ends up being the one that stands the test of time. But there was a clear majority decision, so it hasn't left the matter undecided or left a huge question mark hanging over it. It's only two judges who issued a minority judgment, but it's not to be unexpected. It really isn't. When you've got a very difficult legal matter that there isn't other precedent to rely on, you do expect there to be some differences of opinion within the bench.
Dan, just to build on what Kelly is saying, because I think there have been several others that have looked at this judgment and the way in which it has been penned, both the majority and especially the minority judgment, and see the kind of role that the minority judgment in particular can play when it comes to advancing the law in this country and actually coming to a determiner in future about how such an unprecedented issue must be dealt with, and perhaps create law for that even within the lower courts.
Thank you, Cathy. I certainly agree with Kelly that this is a novel area of law. The Constitutional Court hasn't had to, deal with a direct application for imprisonment for the crime of contempt of court. I do think also that the point that there's a minority and a majority judgment is somewhat overstated. As Kelly mentions, only two justices dissented from the judgment, the main judgment, and it's not a case where you have a 5-4 or similar margin where it's clear that there's difficulty or there was difficulty in arriving at the decision. So there is a decisive majority. I do think that future courts will have to kind of delineate and draw out the limits or the contours of this particular judgment and its impact. But when you read both judgments, it is clear that they depart from two very fundamentally different areas. And so the disagreements are not only about, whether or not former President Zuma should be sent to prison, but also just about how do we bring contempt of court applications or proceedings for contempt of court. So there are fundamental differences that wouldn't have been helped, and these two judgments, as I read them, lead me to believe that these judges would have ended at different polls if this question had presented itself, with a different set of facts and maybe different parties.
The outcomes may have been different, Kelly, but I think that there are common threads. There are things that both judgments agreed on.
Yes, well, I mean, both judgments, the most important thing to say is that both judgments agreed that Mr. Zuma is in contempt of court. And both judgments agreed that some form of imprisonment would be appropriate. That's the end of where they agree, essentially. So, the minority judgment takes the view that if a court on civil contempt proceedings is issuing a purely punitive order, that it's not an order that provides the accused person the opportunity to remedy what's at fault, to remedy the fact that they haven't abided by a previous court order, then that gives it a criminal flavor. It makes it a criminal proceeding. And at that point, the minority believes that the fair trial rights enshrined in the Constitution are then activated and are enjoyed by that person who is essentially now a criminal accused person. And therefore, the correct thing to do is to refer the case to the Director of Public Prosecutions for a full criminal trial to occur and proper criminal sentencing procedures to occur. The majority completely disagrees with this. They've looked at the little pieces of helpful precedent that we've had before this, and they have construed those earlier cases to say that in the correct extreme circumstances, even civil contempt proceedings can appropriately have a purely punitive order if that is what is required in extreme circumstances to uphold the authority and the legitimacy of the court. And as they quite correctly say, you can't really picture more extreme circumstances than the circumstances of this court. So if you believe that you have the fundamental right to issue a purely punitive order in civil contempt proceedings, as the majority did, then this would be the case where that would happen. But that was the fundamental ground really on which they disagreed, was their ability to do that at all. The minority believed it should have at that point been sent to the Director of Public Prosecutions for proper criminal trial proceedings, whereas the majority construed the law to give them the power in these proceedings to use a purely punitive, that is direct imprisonment sanction. It appears that the minority would have been more of the view of the amicus curiae in the court, that perhaps it should have been a suspended sentence, providing Mr. Zuma the opportunity to avoid imprisonment by finally complying with the order. I believe the majority used the phrase that would be like flogging a dead horse. As they said, that Mr. Zuma's made it painfully clear that he has no intention of abiding by it.
Well, certainly a judgment for the ages, and one to still continue to mull over. Unfortunately, we've run out of time for this interview. Apologies, Dan. I really wanted to give you another opportunity to come in there. And that's Dan Mafora. He is a researcher at the Council for the Advancement of the Constitution. And Kelly Phelps, she is a criminal justice analyst.